The challenges and hardships faced by black women who were widows of Civil War soldiers and how they fought for their pensions and benefits. Black women who lost their husbands in the Civil War faced many obstacles in securing pensions and benefits from the federal government. They had to prove their marriages, their husband's service and death, and their own moral character and financial need. They also had to contend with racial discrimination, bureaucratic delays, and legal fees. One of the first challenges for black women who had survived slavery was the Bureau's marriage requirement. Women needed to prove they had been married to their deceased husbands to receive survivor benefits. However, because enslaved men and women hadn't been legally able to marry, the Bureau of Pensions didn't initially recognize their unions. In 1864, the government began retroactively recognizing these marriages, but only if they could provide witnesses or other evidence of their cohabitation and mutual consent. Another challenge was to prove their husband's military service and cause of death. Many black soldiers did not have official records of their enlistment, discharge, or injuries. Some had changed their names or used aliases when they joined the army. Some had died in battle, in prison camps, or from disease without leaving any trace. Black women had to rely on affidavits from comrades, officers, doctors, or clergy to verify their claims. Even if black women could establish their marriages and their husband's service and death, they still had to demonstrate their own eligibility for pensions and benefits. The Bureau of Pensions required them to show that they were dependent on their husband's income, that they had not remarried, and that they had not engaged in any behavior that would tarnish their reputation. The Bureau often subjected black women to intrusive investigations and accusations of fraud, adultery, prostitution, or bigamy. Black women had to defend themselves against these charges with testimonies from neighbors, employers, or church members. Black women also faced the challenge of navigating the complex and costly pension system. They often needed lawyers to help them file applications, gather evidence, appeal decisions, or sue the government. Many lawyers charged exorbitant fees or took advantage of their clients' illiteracy or desperation. Some lawyers even colluded with pension agents or doctors to deny or delay claims. Despite these challenges and hardships, many black women fought for their pensions and benefits with persistence and courage. They used the pension system as a way to assert their rights as citizens, as widows, and as mothers. They also used it as a source of income and security for themselves and their families. Some black women even became activists and leaders in their communities, using their pensions to support causes such as education, suffrage, or civil rights. Henrietta Frances Kane was a young widow who lost her husband, John Kane, in the Civil War. He was a private in the 6th Maine Infantry and died of typhoid fever in 1862. Henrietta was left with 2 children, John Jr. and Mary, and a small pension of $8 per month. She moved from Ellsworth, Maine, to Boston, Massachusetts, in 1871, hoping for a better life. But life was not easy for Henrietta in Boston. She struggled to make ends meet and faced discrimination and hostility from her neighbors. She also had a 3rd child, Frank, in 1877, who was born out of wedlock. The father was rumored to be James O'Rourke, a famous baseball player at the time. Henrietta never married again and raised her children alone. In the late 1880s, Henrietta's pension was revoked by the government. She was accused of running a bawdy house, having an illegitimate child, and living with men who paid her bills. These accusations were made by some of her enemies, who wanted to take away her pension and ruin her reputation. Henrietta denied the charges and fought back in court. She hired a lawyer and gathered evidence and witnesses to prove her innocence. Henrietta's case file contains hundreds of pages of testimony, affidavits, letters, and documents that reveal her story and the stories of other widows like her. They show how widows were treated by the society and the government after the war, how they coped with poverty and prejudice, and how they defended themselves against slander and fraud. They also show how widows formed friendships and networks of support among themselves, but also how they clashed with rivals and enemies over money and reputation. Henrietta's case was never resolved. She died in 1894 at the age of 53, still fighting for her pension and her dignity. Her children continued her claim until 1900, but they never received any money from the government. Henrietta's story is one of many that illustrate the real lives of the widows of the 19th century. The VA provides a monthly benefit called Dependency and Indemnity Compensation, DIC, to eligible survivors of certain deceased veterans. This benefit is meant to compensate the surviving spouse for the loss of income and support caused by the veteran's death. However, not all surviving spouses can receive this benefit for life. In this section, we will explore how the remarriage rules for DIC have changed over time and how they affect the eligibility and amount of the pension. Before 2003, a surviving spouse who remarried before age 57 would lose eligibility for DIC. This meant that many widows and widowers had to choose between love and money. Some of them remarried secretly or lived with their new partners without legal recognition. Others decided to stay single and lonely for fear of losing their financial security. In 2003, Congress passed Public Law 107-330, which allowed surviving spouses who remarried after age 55 to keep their DIC benefits. This was a major improvement for many survivors who wanted to start a new life without sacrificing their income. However, this law only applied to remarriages that occurred on or after December 16, 2003. Those who remarried before that date were still subject to the old rule and had to forfeit their DIC benefits. In 2004, Congress passed another law, Public Law 108-183, which lowered the remarriage age from 55 to 57. This meant that surviving spouses who remarried after age 57 could retain their DIC benefits regardless of when they remarried. This law also allowed some survivors who lost their DIC benefits due to remarriage before age 57 to request restoration or continuation of their benefits if they met certain criteria. The current remarriage rules for DIC are as follows. If a surviving spouse remarries before age 57, he or she loses eligibility for DIC unless the remarriage is annulled or declared void. If a surviving spouse remarries after age 57, he or she remains eligible for DIC regardless of when the remarriage occurred. If a surviving spouse remarried before age 57 and lost DIC benefits, he or she may request restoration or continuation of benefits if the remarriage occurred on or after January 1, 1993, and before December 16, 2003, and the surviving spouse was receiving or entitled to receive DIC on December 15, 2003. The remarriage rules for DIC have a significant impact on the financial well-being of surviving spouses. Depending on when they remarry and how old they are, they may lose or keep their pension or even get it back. Therefore, it is important for survivors to be aware of these rules and plan accordingly.